So we were walking to school.
I started thinking about lunch. Mom packed me turkey and cheese.
She's
I really
smart.
want cheese pizza.
Sometimes her mind wanders.
We should have a sleepover.
I remember saying, Laura?
I think I heard Mom say something.
The sign says don't walk.
Sometimes it's so overwhelming.
I really hope she doesn't
I
have
really
another
hope I
bad
don't
day
have
at
another
school
bad day
today.
at school today.
When you can see learning and attention issues from their side, you can be on their side. Go to understood.org, a free online resource with support and tools to help your child thrive.
Hi, and welcome to Under Oath with Michelle Bell. I'm your host, Michelle Bell. I am a licensed attorney, and this is a show where I bring on fellow attorneys, and we give you, the public, legal information without the consultation fee. So I like to start the show off with a segment I call Jury Duty. And this is where I'll ask a trivia question, and you, the audience, can send in your answers. Now, the first person with the correct answer will have their name put on the website. The website is www.mbunderoath.com. Ready for the question? Here we go. What is the name for the offspring of a male donkey and a female horse? All right, send in your questions. While you're there, subscribe on the website. And we are on all the social mediums, Facebook, Twitter, LinkedIn, Instagram, Periscope. I think I left one, YouTube or something like that. Just go ahead and subscribe. You'll get notifications for all the shows, legal tips, and everything of that nature. So submit your answers and come back after the break, and you'll see who my special guest is. See you then. Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. And guess what? My mentor came back to do a second show.
I promised I would. I'm a little more casual today, though.
I know. You know what? It still looks good. It's
Awesome,
great.
awesome.
Okay, good. So what topic are we going to discuss today?
I thought it might be worth it to talk about how to work well with your attorney, because a lot of time people put themselves in difficult situations when they don't understand the importance of a few simple things and the way they interact with their attorney. So I want to make sure that people are able to know exactly what to do as it relates to working with their attorneys.
You know, that's a great topic because a lot of people just seem to think, well, I paid my attorney,
He'll
so
take care, or she'll take care of all
yeah,
of
she'll
it.
take care of it, or I get to tell them what to do, when to do it, and they just have to make sure it's done, not knowing that makes the attorney's job a whole lot more difficult. And no, you don't get to tell me everything to do. You know, you're not the one that went to law school that knows what the rules are, knows the cases, all of that stuff.
You'd be
just
surprised.
because you paid it does not mean you get to do that.
You'd be surprised how many times clients don't understand that.
Yes. So those of you that are watching and you're talking to your friends, please pay attention to this, because you're going to get an inside look into how this should work and why it should work this way. You ready?
I'm ready.
Okay, what is the first thing, which is like a rule number one, that you would like everyone to know when you are in a relationship? Well, you've gotten an attorney to represent you. What's the first thing that they should know?
This is every attorney's pet peeve, no matter, I don't care who you are or what you do. This is where it really becomes difficult for the attorney. When you know more, or the opposing attorney knows more than your attorney about the facts of the case. So in other words, tell the whole story. Yes. Because you put your attorney at a disadvantage if there is information that the other side can find in their investigation that your attorney has no, like if you swear that you've never had a certain set of circumstances happen, but then it comes up in the investigation that you did, but your attorney's the one getting caught off guard from that, it's your case that's going to be damaged. And sometimes the attorney, sometimes their income is affected by that. I'm going to give you an example of that. And sometimes you just end up having to pay more because you didn't tell the truth or tell the whole story.
Right.
So let me give you a real life example of that. I had a personal injury case. A gentleman injured his back. It turned out it was so on the workers' comp theme from last time, it was workers' compensation and a claim against a third-party defendant. That's a whole nother issue.
Right.
But he had the ability to have a personal injury case against someone who was not his employer and a workers' compensation case since he was doing what he needed to do at the time for his employer.
Right.
So, unfortunately, this gentleman didn't think it was important to tell me about his previous back injuries when he was in the service at Camp Lejeune. He conveniently left that out of the history he gave me, and the attorney that was representing the employer was very, very good about requesting medical records from everywhere this guy could have potentially been. And they had his military records. They knew that he had been at Camp Lejeune. He injured his back playing football at Camp Lejeune. So, you know, I was the only one in the room that didn't know that. Now, here's why that's so important. He, if he had told me the whole truth, would have actually had his case become worth more. And here's why. His injury was somewhat speculative in the eyes of the medical examiners. They couldn't believe that what he described happening to him could be severe enough to make him as disabled as he was claiming to be. If we had known about the previous back injury, his doctor would have been able to testify that based on his pre-existing condition, it's even more likely that this little bit of trauma would cause this injury to be that much more severe. And there's a provision in the law known as what we call the eggshell plaintiff. Yep, you know this stuff. The eggshell plaintiff says, theory or doctrine says that if you injure someone that's previously injured, you're responsible for the whole, not just your part of it. He didn't know that, so he hid it from me. So we took a $1 million back injury case, and he promptly turned it into $75,000 of settlement.
Oh my goodness.
Yeah, $75,000 of settlement. Because if I had put him on the stand, he would have lost all the credibility with the jury. I needed for the jury to believe him about everything else as it had happened. And if he lied about that, the jury had been asking, what else are you lying about? You know, did this happen at all? You know, because there was a lot of people, like Tim wasn't even in the area or something like that.
Right.
You know. His name's not Tim. But
Right, I know.
Let me give you his number. but my point is, that's exactly why it's important for you to tell your attorney everything. They can work with bad facts. They can't work with facts they don't know about.
Right, because it's hard to recover from a surprise when it's happening in court. Like, at least, you know, for settlement purposes or in mediation, you know, you guys can go back and forth, you know what's going on, things like that. But if the person is actually on the stand,
and that's a good point, because
it's hard to recover.
If that's a factor in the case, then that gets factored into what the case may be worth, and we don't sit here hoping for this big payday on your behalf, knowing that we've got this other situation that needs to be addressed. We don't set unrealistic expectations. That was the other thing, is that all he heard was that I thought this case was worth $1 million, and of course it was at the time that I knew what I knew. It completely changed the complexion of the case when he decided to be less than complete in his story. I'll just say that.
So I don't understand how you're paying the attorney, right? Tell them everything, because they can't be put on the stand to testify to everything that you said, unless you know there's exceptions to that, of course. But that would be the person you'd want to tell everything to,
but see,
whether you think it's relevant or not.
Some people are concerned that the attorney might not feel the case is worth taking, or they might not feel that the case is worth as much as you'd like to receive for the case. But as I said before, the worst thing you can do is to have your attorney not know all the information about your circumstances.
I agree. That is just a hard thing to do. That's like, for example, like when I have guests on the show and we do the plead the fifth questions, you guys don't know ahead of time what the questions are.
Right.
Some of you, hesitate. Some people
we get
stumble.
caught off guard.
Exactly, you're caught off guard. So imagine that happening when you're in court and it's about, your livelihood, or you trying to get your job back or anything like that. How do you recover from that? The jury sees everything.
Kind of hard to unring the bell at that point.
Yeah, exactly. The judge can tell the jury all day long, oh, disregard that. You already heard it.
Exactly.
Are you really going to disregard it because you've already heard it, even though the judge told you to? Or if you see the shock, facial expression on the client and the attorney, it's like, what? What?
The jury knows when an attorney has been caught off guard, and then they know that their client is not telling the truth, and that's the last thing that you want to have happen.
I know. Everyone watches TV and just think it goes like Law and Order or How to Get Away with Murder and Scandal, and that's how real life goes. No. Annalise has commercial breaks where she can, fix it. But that doesn't work here in
That's
real
right.
life. And I think people have to come to that understanding that a surprise is hard to get over, especially when there's a jury there. It's regular people sitting there.
So look at it from this perspective. If you've hired an attorney, you have to look at your attorney as being a partner in the outcome of your case. You would not want your partner to be at a disadvantage in your business, not knowing what's going on, because then again, you can't make intelligent decisions in the business. Don't put your attorney in a position of having to make decisions about what the case is worth, the strategy in the case, what the case needs to have in order for you to prevail, without knowing all the information. There was no reason in the world for that to ever happen. You have to be open with your attorney.
Okay, so that's like rule number 1.
Absolutely.
Be honest and open with your attorney. Okay, so what's rule number 2?
Rule number 2 is learn how, or be willing to ask your attorney questions. A lot of times, because your attorney is the expert and has all the knowledge and everything, sometimes you have a tendency to nod your head yes when you don't know what he just said or she just said. And they're assuming you understand. So it doesn't help you for your attorney to not know that you don't understand what he just said. Because then what happens is, if you didn't understand what the attorney was talking to you about, and then it comes back up later when it's time to settle the case, wait a minute, you didn't tell me. Oh, I did tell you. You nodded your head yes, that you understood that. Now I've done that, and now you're not happy. So if you want to get an outcome that's consistent with your reasonable expectations, you have to be willing to ask your attorney questions. Now, I will caution you on this. A lot of attorneys have an ego, and they're intimidated about people challenging their authority. So you don't want to ask the question in an accusatory way. Ask them things like, teach me how this works. Can you explain to me why that's important? Because I want to understand it so that I can make sure we're on the same sheet of music. Literally say that kind of stuff. I don't understand what you just said. Can you try to explain it another way? Don't be like, don't do it in a way where they feel put on the spot by the fact that you don't understand, as if they're not being truthful with you. You got it. Again, this is a partnership relationship. You don't want to accuse your partner of trying to mislead you. You want to get an understanding of what your partner is telling you so that it can be to your benefit as you continue to pursue the case.
It's similar like a doctor. If your doctor tells you something and you don't understand, you always ask, well, I don't know, what does that mean?
Yes.
Same thing.
Exactly.
Same thing.
And so it can apply across any professionals that you might be working with, but in this context, we're talking about attorney-client relationships, so you got to make sure that you understand what your attorney is trying to share with you.
All right, so that's great, and we're going to take a break right now. Don't go anywhere. We'll be back. We're going to do office hours, and then we're going to continue with what you should know in the relationship you have with your attorney. Okay, we'll be right back.
This is the story of a boy who was very sensitive to lights and sounds. So he built secret hiding places where nothing could get in. The boy didn't like looking people in the eye. It made him feel uncomfortable. One day, he found out he had something called autism. His family got him help, and slowly, he learned how to live with it better.
Early intervention can make a lifetime of difference. Learn the signs at autismspeaks.org.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. I'm still here with Glenn Garnes, retired attorney, and we're speaking on the relationship between clients and attorneys, right?
Absolutely.
So right now we're gonna go into the segment office hours.
Okay.
Now I do have some questions for you, and they are emailed, so they're on the computer. You're not gonna hear the audio or see the video. Are you ready?
Yeah, I'm ready.
Okay, first one. What should I do if I know a witness is not telling the truth?
You have to let your attorney know. We talked about that in the last segment. You have to, even if it's not you, you have to let your attorney know. Again, you still can't have a situation where your attorney has less information than you do about what's going on. And sometimes that can be sensitive in certain cases. It might be it might be a personal injury case where you know your husband or your wife is lying about the extent of their injuries, but your attorney needs to know that so that they can hopefully coach them through coming to their senses and not damaging the case the way we talked about in the other.
Or committing perjury.
Committing perjury.
That's
and
a
that's
problem.
the big one. Committing perjury is the last thing that you want to set yourself up to do. So, yeah, so if you know a witness is not being completely truthful, candid, or whatever, then you need to let your attorney know.
Okay, great. One more question, and that would be, what should I do if my attorney says my case is worth $100,000? Then when it's time to settle, my attorney says, nah, the case is only worth $50,000.
Okay, so what you have to understand is that when you first walk into your attorney's office, they know very little about your case. They know only what you've shared with them. And sometimes they're able to verify and validate what you've shared with them. And sometimes based on their investigation, circumstances change. So you have to be open to the possibility that something that came out in your deposition, something that came out in the documents that you provided, something that came out in the evidence that was provided by the other side might have affected the strength of your perspective on the case. For example, you might have thought that you had the green light and the other driver thinks they had the green light, but there's a third-party witness that you didn't know about that saw you go through the red light. If that comes up after the attorney's evaluated the case, then of course that's going to change his opinion, her opinion on the case. You can't hold the attorney responsible for a change in facts that materially changes the outcome of the case.
Right. Basically, I think when people come into the office, they're coming to you, they're telling you in that consultation, they're telling you like quick facts. They're showing you whatever papers they may have, and you're not getting the entire story, even though they think they're giving it to you. You have not conducted your own investigation into it. So you're literally just hearing about the situation. So from those facts alone, you could probably say it's a $100,000 case.
If these things all turn out to be true, then this
Right.
case could be worth a range of X to Y or whatever.
Exactly.
I think attorneys sometimes paint themselves into a corner. They want the client to hire them, so they sometimes can be a little bit unrealistic about the picture they paint for them. But usually there is a legitimate reason why the value of a case turns out to be different. And that could be a personal injury case. It could be a family law case. You know, it could be, you know, people seeking custody. Yeah, exactly. It could be people seeking custody of a child. All of those things change the change the dynamic after you start getting information and getting investigative resources geared up to find out what you can prove.
Right.
You know, just like Denzel Washington said in what was it, Training Day. It's not what you know, it's what you can prove.
Right. And that's the truth. That's exactly what it is, what you can prove. Yes, this may have happened to you. Yes, it's unfair, but can we prove this? If we can't prove this, I mean, you're just stuck with it was unfair,
Exactly.
unfortunately.
So as a client, remember, your attorney is your partner in the outcome of the case. They're not trying to put you at a disadvantage. What they're trying to do is make sure you don't put yourself at a disadvantage based on their experience with the law.
Okay, good. So I hope those those answers answered the questions that were sent in. Those were great.
Good.
Good. Okay, so now we're going to go back.
This
and
is a lot
continue.
easier than practicing law.
Is it?
Because I've been through all these circumstances with clients over, 30 years of being licensed to practice law. You know, you come across some really interesting things.
Spoken like a real retired attorney.
Exactly.
You know, you don't have to rub it in to those of us that are still practicing, all right, that are still, you know, having our struggles. So I think when we left off last time, we finished 2 points, 2 things that the audience needed to know, which was one, be truthful with your attorney, and the second one was, I'm sorry, be open and honest with your attorney. Be open and honest with your
attorney, and also ask questions.
Ask
be
questions.
open to answer questions.
So what's the third thing that the audience needs to know?
Well, that's where I talked about be flexible. You know, they actually asked that in the question. Interestingly enough, you need to be open, be flexible, because, like I said, things change during the course of the case. You know, some things change. I'll give you an example. Some things change have nothing to do with the merits of the case. Think about this. I had a situation where a witness that was going to testify in our case died.
Oh.
And the other side didn't know that the witness died. But if we had gone to trial, they would have figured that out very quickly. And again, we would have been really in a difficult situation. So I was able to keep that from coming to their attention until after we had negotiated a settlement. But we had to do it in a way where we came substantially off of our original position at a time that was close to trial. And my client was beautiful about it. They understood. They understood that there was nothing that anyone could do about that, and that nobody had any control over it, and ultimately we were able to get that case settled. Now the other attorney was very upset that they didn't find out first, but we didn't hide it from them. We just didn't educate them on it. And we're not required under law to tell them, hey, by the way, this case just went down the tubes because the witness A died. We're not going to be able to call them. As long as you're not misleading them, it's okay to use that as a basis to go in and try to settle the case before they find out about the bad facts. You know, it's one thing to mislead them. It's another thing to try to educate them on the bad facts. And your witness dying is one of the worst facts you can have when you're depending on that witness, you know?
It is. So basically it just looked like, you know what, this person, we just want them to be comfortable. We're not even trying to get rich off of this. So we'll take this lower amount.
Yes.
Versus, the original amount that we asked for.
Exactly.
So,
and the client ended up being happy.
Oh, yeah.
But they would have been happier with the other figure because we were looking pretty good till that witness died. We had the only independent witness. Otherwise, it was their word against the other party.
Right.
So.
Well, that's a tough call.
Yeah.
All right, so we have that. What's another point?
When I guess as a client, I know it's tough sometimes when you start thinking about how much money you're paying in attorney's fees, especially when you're paying hourly versus a personal injury case where you only pay after you get a recovery. That's not the time to nickel and dime your attorney. If you want quality representation, you have to be willing to pay for it. And if you can't afford it, then you should get what you can afford. You can't afford to do a $500-600 hour attorney and then wish that they would charge you $250 an hour. Go to an attorney who has the level of experience that you need, but the hourly rate you can afford. It's like being in a Bentley and you can't afford the payments. That attorney's not going to be in the case long enough for you to be able to help.
Or you put unleaded gas in it.
Yeah, exactly. You can't expect Johnny Cochran to show up for $150 an hour. You can't expect Johnny Cochran to show up at all now, bless his heart, rest in peace.
Right.
But you understand the point. You're going to get what you pay for, and you have to realize that the attorney is there to represent your interests, and they charge what they charge. I used to encourage my clients if they had an issue, and very rarely did they have an issue, because most of my clients were referred by other people who I had represented. So they knew what to expect. They said, don't go in and nickel and dime in this guy. But sometimes I would have to say to them, listen, if you are not able to sustain yourself at the retainer and rate that I charge, here's a list of other attorneys who charge less. Just remember that I might be able to answer your question in 3 minutes at $500 an hour. This other attorney might take 5 hours and have to go to the law library. So which one is really more cost effective? And then when they realize that, they're like, all right, here, well, represent me. But yeah, so you got to be realistic about what to expect with attorney's fees.
Okay, there's another one, and I know a lot of attorneys, and you can tell me how you feel about this. There are a lot of attorneys that, they view it a little differently, but I'm big on work style, work habit, and personality, because that relationship can go south real quick if the personalities don't mesh.
That's right.
So I'm a big person on, if the hairs on the back of my neck stand up, then this isn't for me. Nothing against the person personally, but that just lets me know, okay, look, there might be a personality issue that may come up later, or work style. Because I'm one that, I'm a teaching attorney. So I'm one of those that this is what we're doing, but I also need you to go home and I need you to look at this court's website, and they have on there, okay, what you should wear to court, what you should expect when you go to court, like all that stuff. I need you to do that. They also list the rules in layman's terms. So I try to get the person to read those so that they kind of understand. So when we do speak again, it's not complete,
And that's a very, very good practice. It's very considerate of you to be focused on preparing your client for how to best put their best foot forward on their behalf and in your pursuit of the case for them. I love the fact that you do that. It's important because a lot of clients, they don't understand that, oh, let me just drop it off. The attorney will take care of everything. No, You're the one that's going to be on the stand. You're the one that's going to have your deposition taken. You're the one who's going to go to the independent medical examiner and have your, your physical condition assessed. Your attorney can't do that any more than your personal trainer can go to the gym and work out for you. You've got to be a participant and a partner in the outcome of that case.
Right. I mean, I can't care more about the case than you.
Exactly.
This is your case.
That's exactly right.
This is what's happening to you. You know, I'm still employed. You know, I still have, when I leave the office, you know, I'm leaving the office and going home or wherever it is that I have to go. I'm not in that situation that you're in. So you have to help and play a part in it. But I don't want you to be uninformed. Like, you have to know certain things. Do I expect you to read the statutes and regulations and understand what that means? No, I don't. But I do expect you to know, okay, if
what a deposition is.
Exactly.
Why you have to answer these questions under oath and
Exactly.
truthfully. Why I need all of the documents regardless of what you think I need.
Right. Just because you think it's not important
Why
doesn't
is
mean
this
that it's not. Exactly. So that for me, and you know, since I am that teaching I let them know, if you're not going to be involved as much as I'm telling you to be involved, then this isn't going to work.
We might as well not work together.
Exactly. You know, and that's wonderful that you can pay the fee and all, but if you're not going to work with me because that's my style of it, then I usually send them with other attorneys' information.
So you're right. Personality clashes can be a big challenge in being able to provide proper representation to clients. The fact that they have the money to pay your fee doesn't mean that you should accept the case. And the fact that if you really want to help your attorney maximize the potential for a favorable outcome, then you need to be humble and willing to learn and not try to tell the attorney how to practice law. They need to know the facts. They don't need for you to tell them what to do with those facts. I mean, unless you just hired an attorney that's not competent, and that's rarely the case, that the client knows more about the law than the attorney does. So don't assume that your attorney knows less than you about what to do. Otherwise, you pick the wrong attorney.
Pretty much. So that was great. We're going to take a break. And when we come back, we're going to go back to plead the fifth.
All right.
Do you remember that?
Yes, I do. And I'm going to try to be better prepared. But I don't know. You don't tell me ahead of time what you're going to ask.
Of course not. That takes the fun out of it.
It does. It does.
So we'll be back after the break. I'll see you then.
I'll be right back. Hi. You think you're probably sober?
Yeah.
But you're thinking about taking the back roads home, just in case. If you're probably sober, then why would you do that? Good choice.
Probably okay isn't okay. If you see a warning sign, stop and call a cab, a car, or a friend.
That's a full glass of wine. I'll be chatting you later.
Welcome back to Under Oath with Michelle Bell. I'm your host, Michelle Bell. And I'm here with Mr. Glenn Garnes, a retired attorney, but still involved in the law in some sort of fashion.
Only when people can't afford an attorney. Do not try to hire me.
So we're going to go straight into plead the fifth. Are you ready?
I'm ready.
All right. What movie quote do you use on a regular basis?
My cousin Vinny.
Which one? Which quote?
The one about were these magic grits?
That's a good one. What was the last song you sung along to?
Oh my goodness, Mariah Carey. I told you, my girl,
Really?
the hero. Yeah, I sing that a lot because it. And George Benson, The Greatest Love of All. Those both have a lot of meaning to me.
Cool. What was the worst hairstyle you've ever had?
Probably this one. In high school and college, I had the largest afro in the history of afros. Oh man, it was big. Yeah, that was the time of afros.
All right, finish this statement. Back in my day, we
walked 100 miles back and forth to school. I'm going to plead the fifth because I know that you're running out of time. I could be here thinking about that forever. That's a good one to plead the fifth because nobody's thinking I'm being evasive.
So what makes you roll your eyes every time you hear it?
Oh, when I had clients that used to say to me, I didn't realize you needed to know that. Oh my God. Let me smack you out of that chair.
So, okay, well, that's it. We did our 5 questions. You did good.
Yeah, I only had the one that I pled the fifth to, so good.
Yeah, that's still good. So now we're going to go into cheat sheet, and that's where you're going to give the audience 3 quick tips. What are they?
So these are tips that are more in alignment with you supporting your attorney. If your attorney does a good job for you, please recommend them. A lot of attorneys don't do a lot of advertising. They usually get referrals. And if you tell your neighbors and your friends about your attorney, then the next time you have to go back to them, they're going to remember you took care of them. So if you want to, you should be looking to nurture your relationship with your attorney even after the case is over, because you never know when you're going to need them again, especially if they're a general practitioner and you can go to them for multiple things.
Okay, second tip.
Second tip kind of builds on that a little bit, I think, and that is that when you, let me see how I can describe this. It's one thing to make referrals to your attorney. It's another thing to make sure that you, as I said before, cooperate with your attorney and to be able to let people know what they were like to work with. Because you want to be, you know, if you do make a referral, you want to let them know they'd be a good match for you as long as you know to behave yourself or whatever. So if you do make a referral, give the other person some expectations, some reasonable expectations about how to best work with that. Basically, educate them on what you learned from working with that attorney.
Okay, and the third tip.
I'm not sure. I'm trying to draw from my wisdom bank here, but the truth is that I'm coming up blank. So let me see if I can come up with one that would be meaningful for people.
Hey, I got one.
Go ahead, and I'll address it.
So attorneys are like doctors. If you don't like what the first one said, go get
a second opinion. That's a great. Yeah. Oh man, that was perfect. You were right on time with that one. Yeah, you don't have to accept the opinion of an attorney about what can be done in your case. Not everyone is going to have the same feeling about the merits of your case and how you what the outcome could be. It doesn't hurt, and you shouldn't be hesitant to let the attorney know that you're going to seek a second opinion. Don't seek a second opinion after you've already hired them. That destroys the relationship.
Right.
Come back to them and let them know. Let them know right up front. This case is very important to me, and I've been referred to 2 other attorneys. I don't want you to take it personally, but I have 2 other friends I really trust. They told me to speak with all 3 of you so that we could find out what the best match is. I like what I hear from you so far, but I don't want to make a decision until I've had a chance to speak with these other attorneys.
And that's perfectly fine.
That's right.
So those are
if someone's offended by that, they're not the right attorney for you to work with. So thank you for filling that gap for me.
Yeah, you know, hey, I had to dig into my personal experience.
And at least your viewers know that we're not like we don't rehearse these ahead of time.
No, not at all.
Otherwise, I've been prepared on all those. So.
Right. So, but thank you for coming on the show.
My pleasure.
I hope the audience had, got great information and had a great time listening to this, because these are things that you need to know, especially from attorney's perspective. So definitely, please go to the website, which is www.mbounderoath.com, and subscribe there. We're on all the social media: Facebook, YouTube, Twitter, I believe Instagram, Periscope. Like, go to all of those, subscribe. You'll get our legal tips, you'll get the notifications of the shows, and you can watch the past shows. And definitely upload your questions for Plead the Fifth and for office hours. So I'll see you next week.